Welcome to Notable Approvals. I am attorney Amanda Shaffer. It has been a long time since I've been on here live. We've been pretty busy over here at the Shapiro law firm. Also been taking a little vacation, which we all need some R&R at some point. But I'm very excited to be back and talking about our case today. Before I get to it, quick reminder, don't forget to like us and follow us Facebook, YouTube, Instagram, wherever you are watching. And if you find this video to be helpful or know someone who may find it helpful, please hit that share button. So today, as I said, I am very excited to talk about the case. This is a client who I've known since 2012. She was literally one of the first clients that I ever worked with. I think she started working with Aaron like a month or two before I started working as a lawyer, started working here. So she was one of the first cases I ever worked on, and it's been a very long journey for her. So let's go through that journey. And as the headline says, that this client she's almost a U.S. citizen. She passed, I just came from USCIS with her. She passed the naturalization interview, all parts of it. So she just has to take her oath, which we should be next month. So congratulations if you are watching. I know she was very excited and she did have to go to work. So I hope she gets to watch this later. Anyways, so this is a client, citizen, native and citizen of Mali. She had we'll get to her husband in a little. She first entered the U.S. in April 2000 with a visitor visa, and I believe it was not in her own name. She applied for asylum in 2005, so that's 5 years about after she entered. She didn't even have an attorney when she filed. Unfortunately, because it was 5 years after she entered the U.S., she was outside of that 1 year filing deadline and could not be granted asylum. But she was granted withholding of removal by the immigration judge. If you're watching and you're not sure what withholding of removal is, I do have videos on it, but just a quick refresh that it's essentially the same thing as asylum in that you have to prove that you are a member of a protected ground, that you've been persecuted in the past, and that you will be likely to be persecuted in the future. It's harder to get withholding of removal. Instead of having to prove what they call by a preponderance of the evidence, which is about 50%, 51%, you have to prove by clear and convincing evidence that you meet all the requirements, which I like to say is about 75%. It's more than the 51%. It's not as much as in a criminal case where you have to prove something beyond a reasonable doubt. So it's harder to prove withholding removal, and that's because the law says you should have filed within a year. But she was granted it, and it does mean that she gets to stay in the U.S. indefinitely. She did have to renew her work permit every year. Now it's every 2 years to continue to work legally. But it's protection for removal, and the main difference between withholding of removal and asylum why everyone wants asylum instead, is that asylum leads to a green card and eventual naturalization, whereas withholding of removal does not lead to a green card. So that is clearly not how this client got her green card. So let's get into that. And I apologize if I'm speaking a little fast. You can always rewind and watch again. Like I said, this case has been going on for 11 years, so a lot to talk about. So she had withholding of removal for a number of years, and then in 2012, she finally got married for the first time. And this was her U.S. citizen, naturalized U.S. citizen that she married, and he was from the Ivory Coast. And right after they got married, he filed the I-130 marriage petition for her. Unfortunately, shortly after their marriage, as we've seen way too many times, her husband started to become abusive towards her. There was physical abuse, there was emotional abuse, psychological, sexual abuse. He would threaten her, and force her to have sex with him. He would harass her and her family. So eventually, she sought out some counseling services in 2014 and filed a family offense petition against him to get a restraining order. She did get a temporary, we call it in New York an order of protection. I'll use restraining order since it's more widely known. And then in April of 2014, she received a final 2-year order of protection against her abusive U.S. citizen husband. So, as always is the case, when these things happen, what happens to the immigration case? Well, in this case, she decided to file for VAWA under the Violence Against Women's Act. As a reminder, you do not need to be a woman to file a VAWA. You just have to be the abused spouse, child, or parent of a permanent resident or a U.S. citizen. So in June of 2014, we changed her filing to a VAWA filing. And with that, we included, so whenever I talk about VAWA cases, if you watch some of my, or really any case, if you watch my other videos, I always say that we don't send things until we have all of the evidence. There are some exceptions. This is one of them, and when a client is in this position. So she had her I-130 pending, her marriage petition. That meant that the clock was ticking. There was going to be an interview. We don't want anything to be negative. And we wanted to get it filed as fast as possible for her. So actually, when I went back and looked at the case before I came on here, I was like, we got a request for evidence? We don't get requests for evidence. Back then, things were a little different. Remember, this was in 2014. But we did file a very detailed affidavit that she wrote. We filed the family offense petition and the orders of protection. And again, if you're filing for VAWA, there's zero requirement that you actually have, that your abusive spouse, parent, or child is arrested, or you sought protection from the family court. It definitely helps, but that isn't a requirement. She got the letter from the social worker she was seeing for counseling. A friend wrote an affidavit who was witness to the abuse. And we also said that there's evidence of extreme hardship here, and we put in the withholding of removal grant. And basically, the extreme hardship showed that, look, she can't go back to Mali, no matter what, even though technically the withholding of removal order, well, we'll get to that in a second, but at this point, it was still in place. So a few months later, like I said, we got a request for evidence, or an RFE, and we put in some additional evidence, including evidence she resided with her spouse, so landlord letter, an affidavit of a friend. And remember, we did submit other evidence with the marriage petition, of course. We put in evidence of her good moral character, 3 more letters from friends saying she's a good person, and a background check from New York State. And then some more evidence that she entered into a marriage in good faith, which included some more affidavits, a copy of the cover of her DVD wedding video, and photos from the religious wedding. In May 2015, her VAWA was finally approved. This meant, well, great, we have an approved VAWA, but she has technically an order of removal. So when you have withholding of removal, they're literally enforcing this order of removal. So we had to wait for the VAWA, and now we had to get DHS to agree to reopen her case and terminate it so she can get her green card with USCIS. So that's what we did. Very quickly, right away, we filed a prosecutorial discretion request with DHS. So this was in the Obama years, and this was when they were still allowing them back then. But when you have someone withholding of removal who has an approved VAWA, generally speaking, they allow the case to be reopened. Even during the Trump years, I've had cases reopened that were similar because they don't want her to have to stay here without lawful status. They want her, well, not without lawful status, without being able to, without a path to a green card, because her status was withholding of removal beneficiary. So she had her status, but she couldn't get a green card. So if a withholding of removal beneficiary ends up having a path to a green card, especially a VAWA path, DHS, even when they have less lenient prosecutorial discretion policies, are generally more open to agreeing to it. So they did agree. It took a year to hear back from them. And as soon as they agreed, we filed a joint motion to reopen and terminate with the judge. And in June 2016, pretty much right away, the judge granted the order and the client's case was terminated. Now, there is a risk when you do this, and I kind of alluded to it earlier. But basically, when we asked the judge to reopen the case and terminate, we asked the judge to take away her withholding of removal, because that's the only way it can be done. If she had asylum, not only would she have a separate path to a green card, but there's no order of removal. So we wouldn't have to vacate the asylum. So essentially the withholding of removal was vacated, and she, was taking a risk. Now, what would have happened had her green card gotten denied? They could have put her back in removal proceedings. Would they have? I don't know. I've never had that happen. We're very careful when we do reopen cases for someone who has withholding of removal that they're going to get their green card granted. I've never not had it happen, but I'm sure it does. And, could she apply for withholding of removal again? Possibly. So there's a lot of questions there. Luckily, none of that we had to deal with. So then as soon as the judge granted the motion to terminate, we filed for her green card. And that was in July of 2016. And this is the part that took the longest. Who knows why? Because it wasn't until October 2019 that she had her green card interview. And I've kind of been with her every step of the way. I went with her. I think she had an interview for that. I'm pretty sure I went with her to that interview, but that was a long time ago. That was the before times, before COVID. But anyways, her interview went great that day. She was granted her green card. Finally, she was eligible to file for naturalization 3 years later, because her spouse was a U.S. citizen. So she was able to file based on the VAWA approval. And we filed for her naturalization this year in February. And we got the interview notice in May, only a few months later. Today was her interview, and she was very nervous, so she wanted me to come with her. She had no reason to be nervous. I knew she was going to get approved. She answered every question correctly. She read, the English line and wrote the English line correctly, so everything was minimum. I was there at 7:15 a.m. That's why I'm doing this so early. We were out of there by 8. It was beautiful. She was so happy, telling me that her American dream finally came true. So if you are watching, I'm really so happy and proud of you. You've come such a long way, such a long journey that you went through. And for me, as an attorney, I don't get these moments that often, especially a client I've known since I started practicing law. And it shows you how long the immigration process sometimes can take. And this is someone who started, some of these dates I look at, like the judge granted it within 2 weeks to terminate, or reopen and terminate. That can happen today, and it does, but usually it takes longer. The VAWA only took like a year and a month. Now the VAWAs are taking can be 2 years. And this is, again, if everything goes right, and even here we had a request for evidence, which slows things down a little, not as much back then. But even when you do everything right, it can take a very long time. Technically, her process, she's been going through immigration since 2007 or 2005 when she filed for asylum, and then she had a break for 5 years. But 2012 was really when the I-130 process started, and it's taken her 11 years now to finally become a U.S. citizen. So it's, I always talk about when VAWA green cards get approved, that it's really fulfilling to see clients how happy they are, how much it's changed their life, and even more so when they become a U.S. citizen. You know, most people who dream of coming to the U.S., they don't dream of being, at least the ones I meet, don't dream of being a permanent resident. They want their citizenship. So this was a very big day for her and me, because I don't get to see every case through to the very end. When I do, it does mean a lot to me. I told her, you don't need me, save your money. But, she was very nervous, and being there, I think, really did help calm her down. So I said, look, this is my favorite interview to go to when I know it's going to get approved. So I'm happy I was right. And if you're wondering out there, I am wearing a new hat. This is from Tel Aviv. Just shout out to Tel Aviv. That was a lot of fun. I just went there. If you haven't been to Israel, I recommend getting there ASAP. I just came back from Israel, Jordan, Egypt. Beautiful countries. Very interesting and informative trip, as well as an immigration attorney, to see different conditions of countries. But, I love the hat. So shouts to John Lauer and Dotan Rosenberg, who gave us these hats, and the set tie in Tel Aviv, great hotel, highly recommend it. So like I said, great start to the Tuesday for me and for my client, hopefully for you too. If you did find this video helpful or know someone who may, click that share button. Don't forget to like us and follow us, Facebook, YouTube, Instagram, wherever you're watching. I will be putting out another video shortly on unlawful presence and unlawful status. So stick around. I will be shooting that very soon. Otherwise, thank you for watching and have a great day.